The Mavrommatis Palestine Concession Case, Greece versus Great Britain. A brief history of Jerusalem. In 1517, Jerusalem was conquered by the Ottoman Turks, whose rule lasted for 4 centuries. However, in the 19th century, the British conquered Jerusalem and was placed under the hands of the British authorities in Palestine. Towards the end of the Ottoman regime, Jerusalem began bringing in foreign companies to provide electrical lights and tramways. In 1914, the council granted the concessions for the supply of electrical lights and tramway system to a Greek citizen, Euripides Mavrommatis. Mavrommatis was to provide electrical power to Jerusalem within a radius of 20 kilometers from the dome of the Church of the Holy Sepulchre. However, work had not begun by the end of the war, and Palestine passed from Ottoman to British hands. In 1921, the British Mandate granted a 70-year concession to generate electricity from the water of the Yarkon River for the Jaffa Administrative District to a Russian Jewish engineer, Pinchas Rutenberg. Mavrommatis challenged the concession, claiming it would interfere with the supplying power to his own concession. With the support of the Greek government, he brought his suit to the International Court of Justice in The Hague. The Greek government asked for judgment only in respect of 2 concessions of electric power and tramway system, namely, the Jerusalem concession and the Jaffa concession. Issues of the case. 1. Was there a dispute between the mandatory and another member of the League of Nations? 2. Could the dispute be settled by negotiation? 3. Did the dispute relate to the interpretation or application of the mandate? The court is satisfied that there exists a dispute, though the dispute originated in an injury to a private interest. Once a state has taken up a case on behalf of one of its subjects before an international tribunal, in the eyes of the latter, the state is a sole claimant. The court stressed out on the nature of a short diplomatic negotiations, which were only a continuation of the previous private ones, and on the views of the parties, were doubtless in the best position to judge as to political reasons which may prevent the settlement of a dispute by diplomatic negotiations. The court said, before giving judgment on the merits of the case, the suit must be in the form in which it has been submitted, and on the basis of the facts established, falls to be decided by application of the clauses of the mandate. The states may or may not submit their disputes to the court at their discretion. Now let's discuss the Mavrommatis case doctrines. Formula 1. Diplomatic protection. This notion that a state is asserting its own right when it takes up a dispute of private origin on behalf of one of its citizens has become known as the Mavrommatis fiction, or the first of 3 Mavrommatis formula. Formula 2. Flexibility in procedural matters. In the words of the Permanent Court, an international court is not bound to attach to matters of form the same degree of importance which they might possess in municipal law. Formula 3. Temporal jurisdiction and temporal reservations. In the absence of temporal reservations, the only other limitation on temporal jurisdiction is the entry into force of the substantive obligation on which the claim is based. The court formulates 3 inferential formulas to international dispute settlement, generally concerning the character of diplomatic protection, flexibility in procedural matters, and temporal jurisdiction and reservations. For these reasons, the Mavrommatis case deserves the designation as a landmark.